Whether a subjective test should apply to recklessness or whether an objective test should apply, in the context of criminal damage, originally the leading case in this area of R versus Cunningham held that a subjective test applied to determine recklessness, R versus Cunningham, 1957. This gave rise to Cunningham recklessness, which asks, did the defendant foresee the harm that in fact might occur from his actions, but nevertheless continue regardless of the risk? Cunningham recklessness was followed in R versus Briggs, 1976. However, the subsequent case of R versus Parker, 1976, modified the test to include closing one's eyes to an obvious risk. These cases were reviewed by the Court of Appeal in R versus Stevenson, where it was held a subjective test applied, R versus Stevenson, 1979. However, this was followed by MPC versus Caldwell, 1982. This introduced Caldwell recklessness. A person is reckless as to whether property is destroyed or damaged where, 1. He does an act which in fact creates an obvious risk that property will be destroyed or damaged, and 2. When he does the act, he either has not given any thought to the possibility of there being any such risk or has recognized that there was some risk involved and has nonetheless gone on to do it. Caldwell recklessness radically altered the law and received widespread criticism. The tension between subjective and objective tests of recklessness continued, with each test being problematic. The difficulty with a subjective test is that it is based entirely on the defendant's state of mind, and it is for the prosecution to prove that the defendant did foresee a risk of harm. It is difficult to prove a state of mind. It allows too many defendants to escape liability by simply claiming they did not foresee a risk. However, Caldwell recklessness is capable of causing injustice as it criminalizes those who genuinely did not foresee a risk of harm, including those who are incapable of foreseeing a risk, as the following case illustrates, Elliott versus C., 1983. Subjective recklessness was held to apply to non-fatal offenses against the person, R versus Spratt, 1990, DPP versus Morgan, 1976, R versus Parmenter, 1991. In addition to causing injustice, other criticisms of Caldwell reckless, whilst criminal damage was subject to Caldwell recklessness, Cunningham recklessness applied to offenses against the person and thus property was given a greater level of protection. The precise limits as to which offenses required which type of recklessness were not fully understood or defined. Having two definitions for the same word was confusing. The test was difficult for juries to understand, having an objective test blurs the distinction between negligence and recklessness. There was uncertainty as to whether the Caldwell lacuna existed.
Caldwell recklessness was eventually overruled by the House of Lords, R versus G.R., 2003. The House of Lords held a subjective standard now applies to criminal damage. A person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971 with respect to 1. A circumstance when he is aware of a risk that it exists or will exist, 2. A result when he is aware of a risk that it will occur, and it is, in the circumstances known to him, unreasonable to take the risk.
Law Case Notes